You brought a lawsuit against two physicians claiming that they were both careless and caused you significant harm and injury. If during the middle of the lawsuit, one of the doctors would like to settle this case, can you settle the case against doctor number one and continue your lawsuit against doctor number two? Would you like to know the answer? Come join me for a walk on the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is maybe yes, and then again, maybe no. In order to properly answer the question about whether you can settle with one and continue your case against doctor number two, you have to evaluate what each doctor did. Did doctor number one go ahead and treat you together with doctor number two? Were they partners? Did they rely on each other? Did they rely on information that each doctor had in order to reach decisions about how to treat you and your particular condition? If the answer is yes, and they are working together as a team to treat you, then in all likelihood, it is likely not going to be possible to settle against doctor number one and continue the case against doctor number two. You want to know why? I'll tell you why. If you go ahead and settle the case against doctor number one, and now you continue your lawsuit against doctor number two, at trial, doctor number two is going to turn around and say, "Why are you blaming me? I did nothing wrong here. I treated this patient appropriately. And if there's anybody to blame, guess what? It's doctor number one." So now he points a finger at doctor number one, but doctor number one is no longer in your lawsuit, which means you've got a problem. Because now doctor number two is going to do everything possible to deflect every accusation against him and point it towards doctor number one. Now, if doctor number one was still in the case, this defense would likely be not happening. Why? Because rarely do you see one doctor pointing fingers at another. So if doctor number one is no longer in this case because you have settled out of this case, they made you a great offer that you simply could not refuse, now you are stuck with having to try not just to show that doctor number two was careless and caused you harm, but now you also have to deal with the doctor's defense that it wasn't doctor number two who caused these problems, it was doctor number one. So now you're fighting this case as if doctor number one is still in the case, but guess what? He's not. You only have to fight it because you let him out of the case since you already settled with him. So now you've got a huge dilemma, and it may be confusing for the jury. And unless you are crystal clear in exactly what you are claiming, and you are able to overcome the doctor's defenses, doctor number two's defense, by pointing a finger at doctor number one who's no longer there, guess what? You're going to have a very big challenge showing to the jury that doctor number two is entirely responsible for your particular injuries. Now here's something interesting that you may not know, and nobody really talks about this. If you settle your case with doctor number one and continue your lawsuit and go all the way to trial against doctor number two, the jury will still be able to apportion liability or responsibility to doctor number one. Now you might be thinking, what? I don't understand. Doctor number one is no longer in the case. Why should the jury be allowed to consider what doctor number one did or didn't do when evaluating doctor number two's responsibility or liability? I'll tell you why. Because we are claiming that both doctor number one and doctor number two contributed to your injuries, the jury will be allowed to determine what percentage each doctor caused and contributed to your injuries. And so even if doctor number one is no longer in this case, the jury will have to decide, okay, doctor number one is 50% responsible, and doctor number two is also 50% responsible. Now, that could be a huge problem. Why? Because if the jury comes back and gives you, let's say, $1 million as a verdict in your favor, showing you that you are entitled to that money as compensation for all of the harms and losses and damages you incurred because of their carelessness, guess what? Since doctor number one is already out, doctor number two's responsibility is not going to be for the full $1 million. If the jury determines that he's only 50% responsible, then guess what? The maximum amount of money that you could ever recover from doctor number one in that instance is half, 50% of $1 million, which in this scenario, in this hypothetical scenario, would be $500,000. So it does make a huge difference when deciding whether or not to accept an offer from doctor number one before your case ever gets to trial or before this is what we call a global settlement, a settlement on behalf of all the people you have sued. So you have to strategize and think very carefully about what could happen into the future if you decide to go ahead and settle with doctor number one, knowing full well that now at trial, you are now going to have to deal with an empty chair where doctor number two is likely going to point a finger at doctor number one because he's no longer there to defend himself. And the jury will then have to assess how much each doctor is responsible for your particular injuries. So why do I share this information with you? I share it with you to hopefully open your eyes to help you understand how these types of cases work, because nobody really talks about this. And the only time any attorney is going to talk to you about this is when you're in the heart of it, when you're in the thick of it, in the middle of a case, and now you've gotten an offer from doctor number one, and now you're trying to figure out, what do I do now? You know, I realize you're likely watching this video because you wanted to see the beautiful beach. No. I realize you're watching this video because you likely have questions or concerns about your own matter. If you have not yet started a lawsuit and your matter happened in New York and you need answers to your questions, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.